If you've ever looked at a massive construction project, a multi-billion-dollar dam, a new city metro, you know there's chaos underneath the surface. Someone has to be the central authority, the ultimate arbiter, the person who tells everyone what to do.
Hmm.
Today, we are undertaking a deep dive into that figure, the engineer, specifically as defined by the FIDIC 2017 contracts.
That's right. When you give one person this much power to issue instructions, measure work, certify payments, and resolve disputes, you need an incredibly robust contractual framework to manage them.
Right.
The sources we've compiled today are like a blueprint for this person's professional life.
Right.
We're tracking their journey from being a hired agent for the employer to, well, becoming a neutral judge in a multi-million-dollar dispute.
And our mission here is to give you a genuine shortcut to understanding project governance. We are focusing on that central paradox, how this individual can be employed by one party, yet simultaneously be required to maintain total impartiality.
It's a huge conflict of interest on paper.
It seems like it. And if you understand the strict rules governing the engineer, you understand the entire risk structure of high-stakes international construction.
And we will be paying very close attention to the clock. Under FIOC, every action, or crucially inaction, is tied to a hard deadline. Missing a deadline often translates directly into a legal ruling.
Okay, let's unpack this by defining the engineer's identity. They are appointed by the employer, which already sets up a potential conflict, but the contract imposes serious mandatory requirements on that choice. This is not just a favor given to a friend.
Far from it. The engineer must be a professional engineer who possesses suitable qualifications, extensive experience, and demonstrated competence for the scale of the works.
And they have to speak the language, right?
Oh, absolutely. Fluency in the ruling language of the contract is completely non-negotiable. These are, foundational requirements laid out in the conditions.
I find the practical detail about legal entities fascinating. Often the engineer is a large consulting firm or corporation, not a single person. How does FIDIC ensure accountability in that structure?
Well, if the appointed engineer is a legal entity, that entity must appoint a specific natural person, a human being, who is authorized to act on its behalf.
So you always know who to call.
Exactly.
Yeah.
The purpose here is clear. You can't have decisions coming from an anonymous corporate office. Authority has to be traceable.
And to make that traceability official, the engineer has to issue a formal notice to both the employer and the contractor identifying that natural person. It's a mandatory step for the authority to vest.
Correct. Transparency is baked into the system because the contractor needs to know precisely whose instruction carries contractual weight.
Now we get to the core of the paradox, the default position. What role is the engineer supposed to fill day to day?
Okay, so under subclause 3.2, the default role is crystal clear.
Yeah.
The engineer is deemed to act for the employer whenever carrying out their duties.
Except
Except for the specific determination procedures we'll get to later. But day to day, they are an agent, an extension of the employer's will, but always acting as a skilled professional.
But as an agent, their power is strictly limited. They can't just rewrite the core agreement, can they?
No, they cannot. The contract is very firm. The engineer has absolutely no authority to unilaterally amend the contract or to relieve either the employer or the contractor of any of their duties or obligations.
So they administer, they don't create.
Their job is to administer the contract as written, not to rewrite it.
This brings us to what I think is the single most important operational detail in this section, the consent paradox. We know the engineer is the employer's agent, but the contract seems to shield the engineer from the employer's micromanagement.
This is where the contractual structure truly facilitates project speed. If the contract states that the engineer requires the employer's consent before exercising his specific authority, say approving a major change, the operational reality is stunning.
Go on.
For the purposes of the contract, if the engineer proceeds with that authority, that consent is deemed to have been given.
Wait. So if the engineer approves something without formally checking with the employer's finance department, the employer can't later turn around and tell the contractor that the approval was invalid.
Precisely. The contract protects the engineer's ability to administer the project. It legally binds the employer to the engineer's actions, preventing them from imposing further unofficial constraints on the engineer's authority.
Wow.
This means the engineer is functionally independent from the employer's internal red tape, even though they're hired by them.
That structural independence is crucial for project finance and speed, ensuring decisions are made on site, not in a distant corporate meeting.
Exactly. It ensures the contractor can rely on the engineer's word, keeping momentum going. and that independence is immediately tested on the ground, which leads us to managing the site and the delegation of these high-stakes duties.
Right, because a mega project site is massive. The engineer obviously can't be everywhere, so delegation is necessary. How does FIDA manage the transfer of authority?
The engineer can appoint a site-based engineer's representative who must be full-time on-site and delegate authority to various assistants. However, the procedure for this is mandatory.
Another notice.
Another notice. Any delegation or assignment only takes effect after the engineer gives a formal notice to both parties, detailing the specific duties and authority that have been transferred.
I see the consistent theme here. Transparency. The contractor must always have confidence that the person giving them an order has the contractual authority to do so.
Absolutely. No confusion is allowed regarding lines of command. But even with all this delegation, the engineer retains the highest level contractual powers. There are two critical duties they simply cannot push off onto an assistant.
And what are those non-delegable powers?
First, the engineer cannot delegate the authority under subclause 3.7. That's the power to reach an agreement or make a determination, the impartial, quasi-judicial role. Second, they cannot delegate the authority to issue a notice to correct under subclause 15.1. That notice to correct is the serious contractual warning that the contractor is failing their obligations, and it requires the engineer's personal, non-delegable judgment.
Moving to the daily interactions,
Oh, yes.
instructions, the contractor is strictly obligated to only take instructions from the engineer or a duly notified representative. But what happens if the contractor believes an instruction is fundamentally wrong?
Yeah, like if it's unsafe, or it fundamentally changes the scope of work, what FIDI calls a variation.
With their recourse.
This is a huge pressure point on site. If the contractor receives an instruction like that, they can't just ignore it. They must immediately give a notice to the engineer stating their reasons before commencing the work related to that instruction.
And the moment they submit that notice, the clock starts ticking right.
Yeah.
And this clock is incredibly short.
It's the tightest deadline in the contract administration. The engineer has a window of just 7 days to respond.
Just 7.
They must either confirm the instruction, reverse it, or vary it. If the engineer fails to respond within those 7 days of receiving the contractor's challenge, notice the instruction is deemed to have been revoked.
That is a phenomenal protection for the contractor. Silence from the engineer means the instruction just dies.
It does. It forces the engineer to be immediately responsive and accountable. It ensures that challenged instructions don't hang in limbo, paralyzing the contractor's work.
That said, with all this authority approvals, delegation instructions, the contractor is never let off the hook for the final outcome.
That's the final accountability check under subclause 3.2. Any agreement, approval, inspection instruction, or notice by the engineer shall not relieve the contractor from any of its duties or responsibilities under the contract.
So if the engineer approves substandard work and the contractor builds it,
The ultimate responsibility for the defect remains with the contractor. The engineer is the administrator, but the contractor owns the risk of nonconformance.
okay, now we arrive at the biggest contractual shift. We've established the engineer as the employer's agent, but when a formal dispute or claim arises, that role completely flips. How does subclause 3.7 mandate this change?
Subclause 3.7 is the pivot point. When acting under this clause, the contract explicitly requires the engineer to set aside their agency. They shall act neutrally between the parties and are not deemed to be acting for the employer.
This is the moment they put on the judge's robe, so to speak.
It is. They temporarily become an impartial arbiter.
So if they are neutral, what is their primary goal under 3.7? It sounds like they are trying to prevent the dispute from escalating further.
Precisely. Phase 1 is consultation to reach agreement. The engineer must consult with both parties, either jointly or separately, with the specific aim of encouraging discussion and reaching a mutual agreement.
And if that works?
If successful within the allotted time, the engineer simply issues a notice of the parties' agreement, signed off by both. Case closed.
That sounds ideal, but projects often devolve into entrenched positions. What happens when the consultation fails?
That triggers Phase 2, the engineer's determination. If no agreement is reached, or if the parties simply tell the engineer that they can't agree, the engineer must immediately proceed to make a fair determination of the matter.
And this requires them to really do their homework.
Oh yeah, they have to take due regard of all relevant circumstances, assess the facts, and apply the contract terms. And this determination can't just be a quick email, right? It must be given via a formal notice, explicitly titled Notice of the Engineer's Determination, and it must include detailed reasons and supporting particulars.
Right, it's a transparent professional judgment.
It has to be.
Let's get back to those essential deadlines because they define the entire process under 3.7. What are the strict time limits here?
The time limit for the entire process is basically divided into two 42-day segments. The parties and the engineer have 42 days to consult and try to reach an agreement.
Okay.
If that fails, the engineer has a subsequent 42 days to issue their formal determination. 84 days total, but 42 days is the individual clock for the determination itself.
42 days for a single professional to analyze, research, and issue a reasoned ruling on a multi-million-dollar claim is incredibly tight. What happens if the engineer, despite their best efforts and need for neutrality, misses that second 42-day deadline?
This is one of the most punitive aspects of the contract structure, and it depends entirely on the nature of the issue. We have to distinguish between a general matter and a specific claim.
Okay, let's pause and clarify that distinction for you listening. What's the functional difference between a claim and a matter in this context?
So a claim under FIDIC is usually a formal request by one party. Most often the contractor seeking an extension of time or an additional payment. It carries monetary or time penalties. A matter, on the other hand, might be a general disagreement over the interpretation of a specification, something that needs resolution but doesn't necessarily have an immediate price tag.
That distinction changes everything when the deadline is missed. Tell us the consequence for missing the deadline for a formal claim.
If the engineer misses the 42-day deadline for a claim, the engineer is deemed to have given a determination rejecting the claim.
Wow. Automatically.
Automatically. No response equals a denial.
Inaction automatically benefits the employer by rejecting the contractor's request for time or money, even though the engineer is supposed to be neutral. That puts an extraordinary amount of pressure on the engineer to prioritize and complete the determination correctly and on time.
It absolutely forces decisive action. The system prefers a swift rejection, even a deemed one-over indefinite delay.
And what about for a general matter?
Conversely, if it's just a general matter and the engineer misses the 42-day deadline, the outcome is different. The matter is immediately deemed a dispute that can be referred directly to the Dispute Avoidance Adjudication Board.
That makes sense. For a matter, the system jumps ahead to the next stage of formal conflict resolution, whereas for a claim, the status quo is maintained by automatically rejecting the request. It's brutal efficiency.
It is. The goal is to prevent indecision from creating a vacuum on the project.
Once that determination is issued, whether it's deemed rejected or formally reasoned, how does it achieve finality?
Agreements or determinations are immediately binding on both parties. However, they are not necessarily final yet. They can be corrected by the engineer if there are simple clerical or arithmetic errors. The engineer has a short 7-day window to make such corrections. More substantially, they can be challenged.
So what is the formal mechanism for a party to challenge the engineer's judgment?
They must issue a Notice of Dissatisfaction, or NOD. This is the mandatory legal protest, and they have a very narrow window to issue it. The NOD must be given within 28 days of receiving the engineer's determination.
28 days.
This 28-day window is the point of no return.
28 days to process a potentially complex determination, decide if you have grounds to challenge, and draft a formal protest. That's a fast turnaround for high-stakes decisions.
It is, and the consequence of inaction here is absolute. If no NOD is given by either party within that 28-day period, the engineer's determination is deemed to have been accepted by both parties and becomes final and binding.
Silence translates to acceptance. It's the ultimate mechanism to enforce closure. If you don't protest quickly and firmly, you lose the right to challenge that decision forever.
Exactly. And once a determination is final and binding, failure by one party to comply allows the other party to refer that failure directly to arbitration, skipping the DEB.
Because the argument is over. It's just about enforcement.
Right. There is no longer a legitimate dispute over the merits, only a non-compliance issue.
That provides a very clean exit strategy from decision-making, ensuring the project doesn't get stuck in perpetual appeals. But let's look at one final exit strategy. What if the employer decides they want to replace the engineer mid-project?
This is managed under subclause 3.6. The employer has the right to replace the engineer, but they must follow a stringent procedure that protects the contractor. The employer must give the contractor 42 days' notice of the intended replacement.
42 days is a generous lead time. What information must that notice include?
It must detail the new person's name, their address, and relevant experience. This is crucial because the contractor needs to vet the new appointment. The contractor is granted a right to object.
How much time does the contractor have to exercise that veto power?
Only 14 days after receiving the notice, they must state their reasons for the objection. And this is the critical protection. The employer cannot replace the engineer with a person against whom the contractor has raised a reasonable objection.
That's a powerful safeguard, preventing an employer from simply installing a clearly biased or unqualified individual after a difficult determination. It forces the employer to maintain at least the appearance of professional neutrality.
It maintains the integrity of the contractual administration structure, even when the key administrator is being swapped out.
Okay, let's bring all these threads together for you, the listener. We've traced the journey of the engineer from the default agent of the employer, operating with authority often assumed to be consented to the moment they must pivot and act as a neutral arbiter under 3.7.
And we've highlighted that FIDIC is defined by unforgiving clocks. 7 days for an instruction to be confirmed or revoked, 2 periods of 42 days to reach or make a determination, and only 28 days to issue a notice of dissatisfaction or risk final acceptance. This entire contractual architecture is built to cut through bureaucracy and compel timely action.
The ultimate takeaway is that in this high-stakes environment, inertia is not neutral. Failure to act or silence automatically triggers a legal consequence designed to prevent delays and keep those massive projects moving.
This inherent structural efficiency, it raises an important thought for you to explore, the ethical weight of that 42-day deadline for claims. Given the immense responsibility and the required neutrality, what does it imply for the professional judgment of an engineer when they know that any delay or procrastination in making a fair determination automatically results in that claim being deemed rejected? The system is designed for speed, but that speed carries an immediate bias against the claimant if the arbiter is slow.
The fascinating tension between professional neutrality and contractual speed. The contract defines the rules, but the person operating under them holds all the responsibility. Thank you for making this deep dive into contractual engineering with us today. Until next time, keep digging deeper into your sources.